Hello and welcome. In this lecture, we'll be exploring Federal Rules of Evidence 611, Mode and Order of Examining Witness, and 612, Writing to Refresh Witness Recollection. Witness examination is the process whereby a party to a criminal trial is given the opportunity to question and challenge the witness from the opposing party. Now, usually when witnesses come to court, they will bring evidence that support the claims of their party or the part that they're on defending on their side. And this process can be challenged by the opposing counsel, who then will try to either impeach the witness or try to challenge the validity of the evidence that is presented by the witness for their side or their aligning counsel. The process is done in four stages. It starts with a direct examination, and this is done by the party that called the witness to the stand. Now, they may want to elicit a testimony of their character, which is in the form of a pertinent trait, and that is done by direct examination. Now, when the calling party has done that part, the opposing counsel has a chance to then cross examine the witness based on the direct examination. And usually the judge has the power to control the scope of the questions that are being asked, that they do not deviate from the direct examination questions. Next is under number three is redirect examination, and this is usually done by the calling party. And this is limited to matters arising in cross examination. And number four, finally, is recross examination, which is then done by the opposing counsel. And once again, it is limited to matters that have arisen from a redirect examination. And the judge has then control over how those questions are being asked. And if necessary, then we'll have a whole process, a whole cycle taking place that then either if the plaintiff has been the one starting the direct examination, then the next cycle will be the defendant starting the direct examination, and that's how it happens. Under Rule 611, A1, 2, and 3, judicial control is that the judge exerts control of how the process of witness examination takes place to make sure that it's not wasting the court's time and it is procedurally effective according to the rules of procedure, and that the witnesses are not harmed or embarrassed by the examination procedure. Leading questions is under Rule 611C. They usually elicit a yes or no answer, and because of that, the court limits the scope of leading question. They are completely not permitted or allowed in on direct examination. Now, the reason being because the court does not want the parties, either the defense or the the plaintiff, to bring questions that will be yes or no, because then that favors their position only. The court wants the questions to be open-ended. However, the court allows leading questions during cross-examination or when a party calls a hostile witness and, for example, they may not remember some of the issues that have been discussed. The court may allow then leading questions to take place, not to waste the court's time. Rule 612 is writing to refresh a witness recollection. Usually, a witness can be given a piece of writing to refresh their recollection. Now, for example, if a witness does not remember a specific evidence or information or fact, the the recollection or writing to refresh recollection is presented because then it allows the witness to remember the facts of the case. And the process is the piece of writing is provided to the witness. They read silently, and the calling party, they may ask the witness if they do remember the details or the facts. If they say yes, then the witness is then asked to give the piece of writing back to the calling party and testify from their memory. Eh, The the court allows or provides that the opposing counsel may cross-examine the witness and introduce any evidence in order to counter or in order to cross-examine the piece of writing of recollection.